All right, so we're going to switch gears a little bit and talk about record relief in California. And so, just kind of as a quick overview, when we talk about record relief, we do have record relief in California, but not in the way I think a lot of people think about it. So, we talk a lot about a word that's kind of used a lot in California is expungement, but we don't have expungement sort of in the true sense of the word. Records are not destroyed or nullified or voided in any sort of way other than the sort of really unique situation of factual innocence. So, what record relief really does in California is limit the public disclosure of records that have been relieved. And for those entities that are still able to access the records, they get a little note that's attached to the arrest or conviction that says the relief has been provided with sort of the respective statute or the basis for the relief. So, really, record relief in California is about relief from civil disabilities, sort of, it's sort of about protecting employment and housing and things like that, rather than actually sort of wholly sealing or expunging the record. So, record relief doesn't prevent the law enforcement from seeing the conviction or arrest in the future. It does not prevent it from being proved as a prior or used sort of in aggravation. It doesn't restore gun rights, driving privileges, terminate restitution, end an order of protection, or end any obligation to register as a sex offender.
So, Joy, just to clarify, what it basically does, it allows you to, when on housing applications or job applications, you can say, I don't have any conviction.
Correct. Yes.
Heidi.
And then there are these sort of exceptions. There's an affirmative exception for people that are applying for a peace officer position where they have to affirmatively state they do have that contact or that sort of conviction or arrest in that context. But otherwise, a person is able to say, on a private employment application, I've never been arrested.
How does it impact immigration status?
That's a really good question. It doesn't. Having a prior conviction does not change things for immigration purposes.
Having a prior,
So if you have that conviction, the sort of the FBI, the federal government considers that a conviction. It, it
you're still
only
removable or deportable based on the conviction.
Exactly.
Right.
It
It's
doesn't,
like,
the only way that it would sort of be nullified for immigration purposes or is if the conviction is invalidated on a legal basis. Like, let's say, for example, you appeal your conviction, there's insufficient evidence or something for the conviction, the appellate court overturns it. That would be considered like your conviction is no longer legally valid. That is separate from sort of these statutory relief that California provides. Does that make sense? Okay. And so California kind of beginning in 2019 sought to automate this process. So there has been not research in California, but research in other states that do provide conviction relief, that there's an uptake gap, that a lot of people don't end up applying for relief for which they're eligible. So some states and California, kind of following that trend, made this process automatic. So for certain convictions, there's now a burden on the Department of Justice to identify eligible records, and they do this on a monthly basis. And the way the process works is they search their records, they identify, they have their criteria, they identify the arrest or conviction, they add their notation, they then send notification kind of all at once to the respective local court, say, these convictions are eligible for relief. And then for any record the local court has, it then limits public access to that record. So then the only people that can see that record are sort of any criminal justice agency or law enforcement, and then the person who's the subject of the record. And then prosecutor can always object on public safety grounds. And then sort of like when that happens, it gets very technical, but I'll just kind of say as an overview for automatic record relief, it only happens when there is no pending case, a person is not on supervision, and they are not required to register as a sex offender. And sort of as a broad overview, the relief is automatic and immediate if a person is sentenced to probation and completes probation without any revocation. Otherwise, there's sort of a waiting period depending on the nature of the charge. And then mostly for serious and violent convictions, it's discretionary. And so we'll kind of get into the discretionary after Alyssa from CPL talks to us about automatic record relief.
All right. Alyssa, you ready to go?
Yes. Can you
Great.
guys hear me okay? While I share
Yes.
the screen, and can you see my slides? Great.
Looks
Thank you so much. Joy, that was a great overview, simplifying a very complex set of policies. So I'm going to talk a little bit about implementation of record relief using statistics from the California Department of Justice. And this is part of a broader portfolio of research we have that primarily focuses on conviction relief because those carry the most durable collateral consequences. And so we think conviction relief is the most likely mechanism through which we can affect those outcomes. So I'm going to talk a little bit about implementation and then kind of arrest rates after relief. Let's see, sorry. Okay, and with that caveat aside, it is important also to acknowledge that there's a huge number of arrest records that have been relieved. So when the first AB 1076, it was delayed due to COVID. It was implemented first in July 2022. And there were over 9 million arrest records that were relieved in that period across about 4 million people. And then subsequently, there's been about 2 million, over 2 million that have been relieved that we can observe in the administrative records between August and June of 2025. It's a similar story for convictions, though much smaller. There's about just under 2 million conviction records that we can observe received relief in the statewide data, which is about, a little bit over 1.5, 1.6 million people that received relief. Again, big wave kind of right in that initial month of AB 1076 taking effect. So who's benefited from conviction relief? It's mostly people that were in their 50s at the point of relief with records that are, 10 to 20 years old. So the median age at relief was 53 years. Most of those that received relief were male. Women made up about 25%. They're a little bit higher of those with recent records, but still, it's still mostly male men that have received relief. Most recipients were white or Hispanic, and 8% were Black. Most of the records that were relieved were misdemeanors, again, as those are the bulk of convictions, and AB 1076 was mostly focused on misdemeanors. And then again, it's been 2 decades since most people's last record. So for those that received relief, the median time since the last arrest was 20 years and 21 years since their last conviction. When we look at these people, there were about a quarter that still had an arrest that was pending. But for those that had conviction relief, pretty much all of their convictions were gone. So they received a clean slate. But interesting for us, when we look at the administrative data, we still see, looking in July of 2022, when AB 1076 first was implemented, we still see almost 6 million people that have convictions in the ACHS, the administrative records, but do not have anything that indicates that they received conviction relief. So we look at kind of who are these individuals, and my colleague Manny presented a few months ago about the challenges we have being able to precisely identify serious or violent records, but we think there's about at least 1 million people that are not eligible because of the severity of their convictions. About 2 million that have felonies that are likely eligible. Potentially, there's still waiting periods, as Joy pointed out. And then I think what's interesting to us is that there's about 2.8 million people that have a misdemeanor conviction, and we don't observe anything that indicates that conviction was relieved. And so just because we have a little bit more confidence in the misdemeanors, I want to just take a second to look at kind of the age of those records. So the horizontal, the x-axis shows the year of that misdemeanor conviction, and then the line shows for all misdemeanor convictions in that year, what share of those convictions were relieved in July 2022. So you see it's kind of a height of less than 35% for these records that are 40 plus years old. And then there's, goes down as we get closer to more recent years, particularly as some of those records are still in waiting periods. So we don't exactly know why this is happening, but we have a few hypotheses. So I think, as Joy pointed out, prosecutors can object to these records. So it could be that some of these were relieved and then there was an objection. Courts can also provide DOJ with additional information that's not visible to them. Maybe there's a pending case, and so relief could have been reversed. We can't observe all the data that DOJ has. So, for example, we can't observe if someone successfully completed probation. So as Joy pointed out, that can affect the waiting periods. So, I'm sure we're off a little bit in our estimates. But I think there's just, a lot of missing and incomplete information in the administrative records that's probably leading to different criteria that the state's using to automate relief than what we have. So I think those kind of are what we're hypothesizing could be explaining these, lower relief than anticipated. And then lastly, just looking at, despite those potential challenges aside, looking at those who did receive conviction relief, super low reoffense rates, rearrest rates in particular. So we look at kind of everyone that got relief, conviction relief. Less than 1% had a new arrest within a year, less than 2% within 2 years. And, a lot of those people are people that have very old records. So we looked again at a more recent sample, people who finished their sentences within the last 7 years. And again, we see kind of 2% of an arrest within 1 year of relief to 3% within 2 years. So again, really low arrest rates after relief. And stay tuned. We're working on kind of more of a kind of causal study to understand particularly what the public safety, what the arrest rates are as a result of automatic record relief, particularly in California where there's no notification without awareness of relief. Happy to answer any questions.
Yeah, hi, Alice. That was great. A ton of information there. I just have a couple questions. Can you go back a couple slides back to the volume of cases there? Yeah, those couple slides. So
Yep.
I'm just trying to get a sense of like per year as opposed to per 3 year window that you have there. Can you give us
Yeah.
just a rough guess on those numbers? I
Yeah.
understand the COVID backlog, so let's just ignore that. And
Yep. So all of these happened. We see their relief date in July of
I
2022.
understand. That's what I'm
Yep.
trying
So
to
then it's
avoid.
about 50,000 per year after.
Okay, 50,000 per year of convictions.
Yes.
Okay.
It
Um,
varies a little bit by year. I can get you those
no,
actual.
no. I just want just ballpark numbers is fine. And then the disparities or the racial and gender breakdowns I was a little bit curious about. So women making up 25% of record relief, that's, a minority, but it overrepresented relative to their number of convictions. Is that correct? Almost double is my understanding, more than double, perhaps.
I would have to actually.
All
I
right. I'd be
It
curious
is
about,
higher, but when we look at misdemeanors, they are a larger share. I think it's around 20% when we look at
okay, so it's
misdemeanors. Yeah.
closer to maybe proportionate. And I was also wondering about the racial breakdowns too. Those seem not in line with the racial breakdowns of most. Anyway, if there could be comparison against, you know what I'm getting at. And
Yeah.
then
Yeah. We've looked at that historically, so I can send some of that. Yep.
and then similarly on the recidivism data, there's no control group, right? So we don't know what versus or people who don't get record relief.
Yes. So that's the piece. That's the piece that we are working on at the moment. So yes.
Great. All that would be super helpful. Priscilla?
Yeah, so I wanted to I had a question about the racial disparities, and I want to amplify one of the staff recommendations about automatic notification because I do wonder about for folks who don't get relief, right? That does that is part of the issue in terms of reoffending or getting rearrested, that they feel locked out of traditional employment, traditional housing, right? So the fact that they're not getting the relief makes it more likely that they will get arrested for something else because they don't have the types of avenues that folks have when they don't have conviction histories, right? When they're right. So I think that's one thing that's really important. So the criminogenic effect of having a criminal a conviction on your record. Um, and I also wanted to ask about like, so does a new arrest make someone ineligible for automatic records expungement or record relief? Like how do arrests without conviction impact someone's eligibility? Or would that be a basis for a prosecutor to object to someone getting record relief?
My understanding, and Joy, correct me if I'm wrong, is that pretty much it can extend the waiting periods, but it should not make a record ineligible. So if you received relief and then had a subsequent arrest, that shouldn't affect your current record. If you're during your waiting period, and you have a new case, that can extend the period that you have to wait to get that conviction relieved. But it shouldn't render a record ineligible unless it's leads to a conviction for an ineligible offense.
I mean, yeah, because I mean, I'm trying to layer this on with what we know about sort of policing saturation in particularly like Black and Latinx communities. So it's not that hard to get arrested, right?
Mhm.
Especially if there's a significant amount of targeting of, younger people, young men, Black men, Latino men, right? So that I'm wondering if that might help explain the 8% record relief that's been available to Black folks, right? If you live in a community that's over policed, where you're constantly getting stopped, questioned, and or arrested, uh, how does that impact your eligibility? So I'm wondering, like, an arrest, should that extend your wait time if there's not been a charge, right?
Yeah.
Or should you still be eligible so long as there's no new conviction?
Yes. And I think it's as Joy said, I think then that's counted as an open case. So it's until there's that resolution. But I think that's a really good suggestion. And we've looked at this historically, and there are disparities in eligibility for convictions that require petition-based relief, which I think Joy is going to talk about a little bit later. But there's a much higher share of Black individuals in the group that are eligible for petition-based relief compared to automatic relief, which again can contribute to exacerbating the disparities. But I think the open arrest point is a really good and important one to raise.
Yeah,
Thank you.
and the other thing I wanted to amplify is like getting automatic notification is super important because, folks may not know that they have record relief and may continue to disclose
Sorry.
and or just take themselves out of situations that they might want to, apply for housing or jobs. And as it stands, it's as the memo points out, you have to pay money, get a live scan. I think it's also difficult for even public defenders to get their clients' records. So I think either A, automatically notify folks, or B, allow public defenders to have easier access to these records so that they can notify their clients. I think we definitely need to deal with that notification bottleneck.
Yes.
I just add, I was just looking at the statute, and the way it's written is it says that there's no indication of pending charges. It doesn't say a pending arrest, but my understanding is that DOJ is particularly conservative as they're kind of looking at a person's record and deciding whether or not it qualifies. So I think that's something we can look into and investigate and think about further.
Because there's a lot of records in DOJ that don't have a disposition. And so if that's considered pending, so that's a good point as well. Yeah. I see Mary, you have your hand up.
Yeah, so I mean, as far as I know DOJ's under other court orders to, if there's an arrest without a disposition, like as far as background checks go, they have to make concerted effort to verify that it's been dismissed or it's still pending, or not put it on a background check. And that's been in place for decades. But I don't know if they do that with this situation, but I know they're in a habit of looking past just an arrest with no disposition. And also just wanted to mention Lowenthal does have AB 2384, which is adding another layer. It's a petition based, but it's to get records sealed. It's similar to one that I think has failed in the past, but it's moving at this point. So I don't know where that's going to land, but it's to go, and it kind of is another layer within all the layers of various things available at some point. So.
Well, that would be a great transition, actually, unless there are any other questions for Alyssa. Okay.
Thank you, Alyssa.
Yeah, thanks, Alyssa. I just realized you're in Joanna's office. It's messing with my head a little bit.
Right.
Okay.
Stop sharing and get out of here. Sorry.
Great. Thank you very much.
Thank you.
All right, I think I can kick you off.
Please do. Okay, I got it. Yeah. Okay. Stop sharing. Great.
Just let me get back to ours. All right, and now Joy will pick up the baton on that the non-automatic, but you go to court and you ask a court to do something, which was what we had before automatic record release. So there are these statutes that kind of the automatic and the court process overlap a little bit, but they also, you can do things in court that can't happen automatically. Okay.
Great. And before I jump into that, I did want to follow up one thing, Professor Rummel, about the immigration consequences. So just to clarify, so automatic record relief, or kind of this discretionary relief that doesn't sort of change or void the underlying conviction, doesn't change anything for the better for immigration purposes. A person would still be subject to inadmissibility or deportation. There is a statute that the legislature passed a few years ago that sort of allows a person to, allege that they didn't understand the immigration consequences of their case and that it was prejudicial error, which then sort of meets that, legal and invalid sort of, yeah. So the discretionary relief, this is all sort of within 1203.4, which, historically had been a petition-based process, which has been, affected by automatic record relief. The first two sort of are generally included within automatic record relief, but we now have 1203.4B, which for somebody that participated in a fire camp can now apply for relief when they first come out of prison and they don't have to sort of serve any sort of waiting period. And then now under 1203.41, essentially, any felony other than a felony that resulted in a requirement to register as a sex offender, a person is now eligible to petition a court for relief. And the standard for all of these is in the interest of justice, which is not sort of defined anywhere by statute, by court rule. And so it's really, a judge has wide sort of discretion. And Tom will mention it later in our recommendations, but there's no requirement that a judge sort of explain why or make a record as to when a judge denies a person under the interest of justice. So they're sort of left without any sort of understanding as to, when they might be better suited to apply in the future.
Right.
And then sort of kind of to tie into diversion, mental health diversion, military diversion, misdemeanor diversion, all have language in their respective statutes about, sort of that the charges are dismissed and sort of address sealing, but they each sort of do it in a different way. They describe what sort of the impact should be, that a person can say they've never been arrested, et cetera. But only sort of, as in the next slide, you can see that only mental health diversion sort of makes this direction to DOJ to actually sort of fill in the gap and say that this case was diverted, and the court should, restrict access to the record. So misdemeanor diversion, There's no sort of direction to the clerk or to DOJ. And so from what we understand, it's sort of leading to situations that Alyssa kind of mentioned, where there's just sort of nothing is filled in under the DOJ record. A case just still shows as pending when in fact it has been resolved.
All right, so that's, I was going to say a brief overview of the law. That was pretty intense. But let's get to the staff recommendations, some of which have already been discussed. There's 4 here. The first is the biggest one, which would be, let's actually destroy misdemeanor records after some period of time. So the current regime now is it limits access, it puts a notation on them, but they're still available for, I think, many purposes that might surprise people. So our proposal to discuss is it would only be for misdemeanors that received automatic relief, and it'd be some period after automatic relief. We've left that intentionally vague for now to sort of figure out. And we would exempt misdemeanor offenses where they can be used for future punishment. So like DUI, where your second misdemeanor DUI is used to enhance punishment, and domestic violence as well. And I think it's important to point out we would keep the prosecutor's ability to object to this on public safety grounds. So this would be automated record destruction, similar to what we have now for automated record relief, but would take that next step and actually destroy the records. The second is the notice point that Professor Ochin was talking about. So automatic relief is great, but you have to affirmatively go get live scan, which is fingerprinted, and pay to see what your record is, to see if you've gotten relief. Now, for people who've already gotten it, it's a very tricky situation of how you give them notice, because they're, pretty intense privacy issues, and how do you do it? But our proposal is for going forward that at the time of your conviction, you already have to be told about the availability of automatic relief. We take that one step further, and a system would need to be created. And I know that has a big price tag attached to it, but let's just speak about what the policy, whether it would make sense or not. You opt in to receive notice, and ideally via text message, so that, you get, and when your record is relieved or it's about to be relieved, and when it's completed, you get notice from the Department of Justice, and now you know what's happened. So right now, folks have no idea. And as we saw, many millions of people have been affected by this for convictions from decades ago, a lot of the time. Professor Ochin.
Are people notified by like a court or their public defender at the time that they're convicted or sentenced that, like 1 year from now, or whatever the criteria is, you are eligible for automatic expungement if these events happen or don't happen? You don't have to do anything. This will occur 4 years from now if you don't have any new arrests or new convictions or whatever. Are people told this at the outset? Since the law, obviously not retroactively, but since the law has been passed, are courts letting people know this? Because that to me would be an incentive for folks to be like, all right, okay, I'm
Right.
pleading guilty to this, but this can come off my record if I can, not be, certain things are out of the control, but certain things are, and they might keep that in mind.
There's a statute saying they're supposed to be given notice at sentencing about automatic record relief. I don't know, A, what's happening in practice, B, how specific it is. If it's just like, there's this thing called automatic record relief, go figure it out if you want, or if it is like more tuned to their case. And, there's so many of those sort of notices and kind of boilerplate language. I wonder to what extent it sinks in. But as a general matter, yes, you are supposed to be told about it when you're convicted or when you're sentenced.
And the other question I have is sort of like the completeness of records that DOJ has. Like,
Mhm.
have you all looked at that issue? I think there were a lot of concerns about, like, just because we have 58 counties and court systems, and things may not be as complete when transferred to the state system. So I'm wondering, have you all was that an issue that was flagged in terms of how the automatic record relief is being implemented?
Absolutely. And we're actually hoping to devote a part of a future committee meeting to what's called the disposition gap. It's existed as long as we've criminal records where it's some double-digit percent of arrests or convictions. What the final resolution of them doesn't make its way to the state criminal record depository at the Department of Justice. It has implications for this issue. It has implications for people access to firearms and a really long list of things where it's really important. So we're hoping actually to devote some time to figuring out if there's a way we can make some helpful recommendations around it. And you all may have seen there was in the news a few months ago that LA County, I think as a result of transitioning to a new case management system, realized they had not transmitted dispositions in hundreds of thousands of cases over a long period of time. So it ends up being a pretty small proportion given the volume from LA. But they fixed that, and I'm positive that's not limited to LA County. So it's a really complex issue, a very expensive issue, I'm sure we'll be told, but it's something we hope to look at. And I'm glad there's some interest because it's pretty wonky even for us. So I'm glad it might actually get some folks excited. Okay, so that's sort of the automatic record relief part, and the final two staff proposals are this, very technical thing. That was the last thing Joy talked about the diversion statutes not being consistent about how they're transmitting information to the Department of Justice or ordering arrest records sealed. Just, make that, do that one way and have it be as effective as possible. And the fourth one is for these discretionary petitions that people are still filing if they're not eligible for automatic record relief. The court should have to explain why they're saying no, because you can come back and file another petition. It's not like you get one shot. People can come back multiple times. So if they aren't told what they need to do to get relief, they can't decide. They don't know what to do, or if it makes sense to come back. So just a bare minimum, sort of explain why you're denying this. And those are our proposals.
Great. Thank you so much. This is super helpful. And as always, we will continue to consider these. We're not voting or approving any of these proposals until much later in the year, but thanks a lot. So
Great.
Tom, I think now we have some administrative and crime data updates.
Exactly. Minutes, I think we should do first.
Okay. Let's approve the minutes from the November 2025 meeting. I'm
So
going to
moved.
All right. Anybody second?
Second.
All right. Anybody opposed? They're approved.
Great. All right. So here's the things we'll wrap up with. I'm going to just mention open government laws real quick. We'll talk about crime data, and then I just want to put up the schedule for the rest of the year and the topics because we're doing things slightly differently. All these things should be pretty quick, and then we'll go to public comment is the idea. Okay, open government laws. So, the committee has to follow certain state laws around open government. The one we always talk about is the Bagley-Keene Open Meeting Act. I think the most significant things for you all to be aware of are visibly appear on camera during meetings, unless there's technical difficulties or someone sharing a screen. Mike says at the start of every meeting because I make them, but I just want to highlight it here as well. And there's also a prohibition on what are called serial meetings. So committee members can't discuss committee business without doing it in a public meeting. But we also can't have, Mike calls Professor Rummel, who calls Judge Espinoza, and you sort of try to get around it by having one-on-one things. Basically, avoid talking about committee business. And if you have any questions, obviously, let me know.
Well, you can have one-on-one as long as you don't have that daisy chain situation, correct?
Yes. A new term of our daisy chain. I like it. Maybe we can replace serial meeting with daisy chain. Yes, exactly.
But I just want to be clear, you don't mean we can't talk about issues related to the criminal legal system with multiple people on this call because that falls within the ambit of the committee, right? It has to be something specifically that the committee is addressing.
Yes, exactly. Right.
Okay.
And it's difficult because we do cover so many things. But obviously the point is if there's going to be committee business, it has to be done in a meeting, and that's the spirit of it. So I don't think anyone's ever come close to violating that. And the second, there's a number of conflict of interest and contracting with the state rules. Again, I don't think this is really relevant for anyone, but I do want to mention them. If your spidey sense goes off that you think there's something might be implicated, let me know and we'll figure out what to do. And of course, the Public Records Act applies to the committee. And that includes personal devices. So, if there's text messages or anything on a personal device, those may be subject to the Public Records Act. Again, we don't get very many requests for this. We've been able to handle all of them entirely because of the scope of the requests without having to involve committee members. But if that changes, we'll let you know. And there was more details on these in a memo that I distributed to you all a few weeks ago, and it's on our website. So just wanted to bring those to your attention. And of course, any questions, let me know. Okay, legislative update real quick. So we've got a number of bills that are pending. The legislative session for sort of this year started a few months ago. 2 are from Assemblymember El Hawari. Even before she was a member of the committee, she was interested in what we're doing. So I think that's excellent. There are 5 bills that have been introduced this year, so I'll go over those very briefly. The first is from Assemblymember El Hawari, and this would create a new or expand habeas corpus for people to go get their conviction overturned if it was based on gender-biased evidence. Rick is actually testifying in the assembly on Tuesday about this bill, and this is related to a recommendation from the report last year.
This is
There's
kind of
also
like RJA for women or for gender.
It shares some elements of that, but also avoids, I think, some of the problems that we've encountered with the RGA. That's how I would put it. Yes. And it's obviously not limited just to women because that would violate the Constitution, but those are the cases that seem most relevant. Right. And another bill is AB 1595 from Assemblymember Schwartz, who's the chair of the Assembly Public Safety Committee. And this would harmonize the different standards for relief in habeas corpus. Corpus. So some, are preponderant, some are, beyond a shadow of a doubt. There's all these different standards, and there should be one. The law shouldn't be so complicated if you're saying my conviction was inappropriate. Another is from some members of the Burr, and it's around our law enforcement diversion idea lead. We didn't talk about that today, but that's another diversion area where the committee has made some recommendations. Senator Caballero has introduced a bill around lesser related offenses, not to be confused with lesser included offenses, even though it is super confusing to some people. But this would allow, and this was a recommendation we made around guilty pleas. One way to reduce unfair guilty pleas is to increase the scope of what you of lesser offenses you could be convicted of at trial. California had this rule for a long time, and then the California Supreme Court got rid of it. And then SB 1211 from Senator Gonzalez would allow prosecutor conviction integrity units to get greater discovery than they're able to do now in cases they're investigating. And there are 2 bills that were introduced last year that are still pending. Another from Assemblymember El Hawari, AB 1231, which we talked about expanding judge diversion to low-level felony cases, and SB 672, which would make youth offender parole extend to folks who had LWOP sentences. Professor Rummel.
I don't believe 672 is still pending, but that wasn't the reason I raised my hand.
It's technically pending, but seems it might as well not be. Yes, okay. Right.
I was going to speak to just briefly to some of the bills that have been introduced that would roll back or exclude people, especially sex offenders, from opportunities to demonstrate that they no longer pose a risk to public safety. There's legislation around elderly parole. There are, of course, the regulations that have been introduced and revised once by BPH. But I was looking for information on recidivism rates for people who have sex offenses, who go through these discretionary processes, to see if, our parole board and our sexually violent predator units are doing a good job of screening out people who remain dangerous from people who don't. I think that information would be especially relevant to respond to some of these laws that are removing opportunities for people to not to be released, but just to go and demonstrate they don't pose a danger to public safety. So I was going to see if that was something that the committee could look into, and maybe quickly, so that some of that information would be available to the legislature as they consider imposing these limitations on the parole process and related avenues for relief for people.
The the quickly part is the hang up. We're actually in the middle of we're very close to finalizing a data sharing agreement with the Board of Parole hearings that would give us sort of the folks who had gone through that process. And then we plan on doing that sort of recidivism analysis, but I don't think we're in a position to be able to do it now, unfortunately. And there is very general information out there from CDCR about,
Right. But
but
not that
it doesn't address,
distinguishes
right.
between discretionary and non-discretionary releases.
Exactly.
I think these laws are mostly targeted at the discretionary releases. So is
Yes.
that information available? I imagine CDCR has it, right?
I
Office.
don't I don't know. I don't know if they've done that particular, you know, looking at that particular group and getting the recidivism data from the Department of Justice for them. They may have. The recidivism reports they put out are extensive, so I kind of feel like if it's not in there, maybe they don't have it, but I don't know for sure.
Yeah. Well, I don't know. I feel like these laws are impacting a lot of the recommendations this committee has made in the past, and it might be at least useful to have the information available to the legislature as they consider these moves.
Absolutely. I kind of had hoped we would have had the DPH data by now, given how long we've been talking about it with them, but we're still not ready to do it yet, unfortunately. Okay, let's move on to crime data. So, speaking of the California Policy Lab, again, we have been able to make huge advancements in what we can say about crime. So typically when I've done this with you all, we've been able to look at just violent crime in the largest cities in California, sort of the top 8. We can now look at 80% agencies covering 80% of the population. I'll just tell you all that later. The top lines are violent crime 2025 compared to 2024, down about 10%. Big drops in every category. Murder drop of around 17%, robbery 19%, property crime down 14%, and you can see the sub offenses there. Burglary down almost 9%, larceny theft down 12%, car theft down by more than 25%. That was one of those offenses that went up a lot during COVID, and arson also down. And arson last year was the lowest it had ever been. And the property crime rate in 2024 was the lowest in the data, and I think it's going to be even lower now. So I interrupted myself. This is data from the FBI, reported monthly by local agencies in California. It's entirely voluntary. We also then supplemented it with some big agencies like the sheriff in LA and San Francisco and Oakland. Altogether, we're covering about 83% of the California population, so pretty good coverage. But, this is preliminary. Numbers aren't final. It may be different. Side effects may include, et cetera. The final numbers will be out in July, but I think these are going to turn out to be a pretty good indicator of what's happening. And among the lowest crime rates in our history. And again, this isn't a California story. This is happening in the rest of the country as well, but it is also happening here. Professor Ocean.
I wanted to comment on the violent crime reductions, which I think are super important, obviously. One of the concerns that I have, I on the just full disclosure, I'm on the board of an organization called Urban Peace Institute, and they do community violence intervention. And for that field across the country, there have been significant cuts to their funding, and community violence intervention is very effective at reducing uh, community violence. And I wonder if you all have a sense of, and there was a huge infusion of funding at the federal level under the Biden administration, which has been just, decimated under the current administration. And I'm wondering if you have any sense of like what impact investments in community violence intervention might have had on some of these figures, and what we might be able to anticipate going forward given the cuts.
I don't think I could put it better than you did. I think there is, no one will ever say crime went up because of this or went down because of Y. Everyone fights about it continually, but that is one very prominent theory, is that the violence interruption that was sort of supercharged by the post-COVID spending by the Biden administration is what caused a lot of this. And now that it's stopped, we're going to see the numbers go in the other way. So unfortunately, I think we have to wait and see a little bit. Though I will say these numbers are continuing to drop in early 2026 too. So how long would we have to wait to see a negative impact? I don't know, but it's sort of hasn't shown up yet. And I think the other thing that's interesting is we're seeing these numbers drop even as, the police departments are still at pretty historically low staffing rates as well. So there's a lot of different indicators to look at. But I think the violence interruption one it's one that I worry about a lot because it took a long time to get there and very easy to destroy, and to build it back up, I think will be hard, challenging given the environment.
Let me just interject a couple things. So first of all, it's not only so this is we're talking about statewide data, but we have it more granular by county and jurisdiction. So
Yeah, I was about to show you that. You're spoiling the surprise, Mike, but
oh,
that's okay.
I'm sorry, but it would be one way. It would be one way to evaluate some of these differences, and also I think what's one of the things that's two things that's fascinating is that this is kind of going across the country, right? So it's hard to say that this is a specific policy in one jurisdiction or even one state or another that's really driving all of this. Likewise, this is a part of a long-term trend. And so when people come back and say, see, Proposition 36 did all these great things for California, I think that that's, mistake as well. So anyway, sorry to step on your glory.
Okay. Uh, well, and I honestly think this does goes without saying, but when I do talk about these numbers, I do think it's important to point out like these numbers are still way too high. Just because we're seeing decreases doesn't mean crime is not a problem or there aren't way too many crime victims. I think that for me, that I take that for granted, but I do think it's worth saying explicitly. Like it's not really a cause for celebration. It's just facts to take into account as we look at these policies. Okay, so I want to give you guys a preview of a new data visualization that we're working on about this crime data. And again, this is all through the California Policy Lab. This is way beyond my skills to get this data and to do these sort of things. So this is sort of something we're still very much working on. Well, let me start with this one. So this is a tool that will let you look at specific police departments and the differences in 2025 versus 2024 crime. So there's 400 plus agencies here. Let's just look at some big ones. So this is the LA Police Department, and you can see the 2024 counts, the 2025 counts, and the percent difference. So you can like Mike said, go pretty granularly. Let's just look at Sacramento for and what we've done is we've only included agencies that reported every year in 2024 or every month in 2024 and similar in 2025. So we tried to narrow this down to the places that seem to be the most reliable. And again, it's a pretty long list and we're still working on it. So I'm excited about it. So I wanted to give you guys a preview. So this is, what are called the Part 1 crimes, overall violent offenses and overall property offenses. We also are able to delve down into even more subcrimes for burglary and robbery and larceny theft. And that's what this similar tool does. So this looks at shoplifting, which is a part of larceny theft, non-residential burglary, which is a part of burglary, and then the sub-robbery offenses that tend to be of commercial properties. This is what sometimes people look at when they talk about retail theft data. It's not perfect. I've got a lot of issues with it, but we have it, so I thought it's worth sharing. Again, this is looking at agencies that report this. So this is the Alameda County Sheriff's Office. Let's go down to Los Angeles Police Department, goes back to 2022. We see shoplifting reports go up a lot. 2023, 2024 seem to have gone back down. I'm not just going to repeat what the data says, but this is a way to sort of answer some more specific questions. So that was Los Angeles. If we look at Sacramento, shoplifting data looks very interesting. It, quadrupled 1 year, went down significantly, and then went, anyway. So these are the kind of things that exposing this data, exposing meaning sharing it, will let folks do. So this is something we're working on with the California Policy Lab, and when it's ready to go, we'll let everyone know. All right. Almost there, folks. Let me just bring back my other slides. Here we go. So that's our crime data. And we'll just end before public comment on the schedule and topics for the rest of the year. So we've got our next meeting in about a month, May 15th. Rick has been leading our research on that, covering sentencing enhancements, aggravating factors, and 17B reductions and related things. So look forward to getting the material for that in a few weeks. And then we don't have any meetings for the rest of the summer. The plan right now is to come back in September and to have a meeting in a prison, as we talked about at the November meeting. I know we're very interested in doing that. I'm working with folks at CDCR to put that together. We're going to have to be a little flexible on the scheduling. That's why we're sort of going to take some time off, do it in the second half of the year, and I'll be in touch with you all about scheduling. But that's the plan for that. Then we'll come back on October 9th for another Zoom meeting. And then November 20th will be that last meeting where the main focus is to approve that year's annual report and think of topics for the following year. And what do we have coming up? We haven't quite finished attaching these specific meetings yet because we've got some time to do it. But in addition to the sentencing enhancements and related that we're going to do in about a month, we hope to look at bail and pretrial detention, return to that topic, which has been about 3 years since we looked at it. And there should be hopefully a significant decision from the California Supreme Court coming out in a few weeks on that. And then we talked about this a little bit, but looking at the quality of statewide criminal justice data around dispositions and crime data a little bit. And then we want to look at CDCR programs, and I think some of the elderly parole and how to deal with elderly people in prison, even outside of the parole context, and some other programs. We'll talk about that. So that's sort of what we have planned for the rest of the year. And now we can go to public comment if there's no more questions or discussion to be had.
All right, unless anybody has anything else to say, let's go to public comment. So for those listening on Zoom, please get in line to comment. Please select the raise hand function in the Zoom. If you're calling in, you can hit *9, depending on how many people get in line. I'll decide how long each caller has. Can you share the Zoom waitlist, Tom?
Yes, we've got 2 folks.
All right. Let's do 90 seconds.
Great. Samuel Fishman. And someone else just signed up as well.
Hi, thanks so much. Good morning.
Morning.
I'm Sam Fishman, a staff attorney at Legal Services for Prisoners with Children. We're a California State Bar funded support center out of Oakland. And I'd like to provide a brief comment on the recommendations to improve court communication with people who are eligible for record relief, including automatic relief and explanation of denials, if that's okay.
Yes, please.
So we think that for those who are denied court-based relief, and then I've done a lot of litigation in this arena, a clear explanation would allow these petitioners to address any of the court's concerns and to reapply with that knowledge in mind so they don't give up because they don't understand why the petition was denied. We think that requirement should be provided in writing and in plain language, if that makes sense. And also, more on that matter, we think that there should be presumptive relief if certain statutory criteria are met for these discretionary positions. And basically, we believe that courts should be required to grant this relief unless the prosecution or the people can provide a specific current risk with clear and convincing evidence. I just want to say that, as you guys already talked about, this Los Angeles Superior Court just identified 464,000 cases across 400,000 individuals whose cases were not reported to the DOJ. We think these people might lose employment, might lose professional licenses, might lose their housing, all of these things that they obtained and they thought lawfully. So we applaud you guys. We thank you guys because modernizing these systems, expanding the mechanisms and eligibility for relief is really super important. And thanks for taking it seriously.
Thank you, Sam. Well, who's next?
Natalie Smith.
Hi, Natalie.
Hi, good afternoon, everyone. I'm Natalie Smith, another staff attorney at Legal Services for Prisoners with Children. I'll echo my colleague Sam in applauding many of the recommendations on record relief and encourage the committee to extend several proposals even further. As noted in the staff recommendations, California lacks true record sealing, leaving many Californians vulnerable to continuing civil legal consequences of conviction, particularly record-based denials of employment and occupational licenses, all despite having an expunged record. For example, a person with any conviction is barred from working in a community care facility licensed by the Department of Social Services, even if that conviction has been expunged. The proposed destruction of misdemeanor conviction records following automatic relief will remove barriers to work for many people with expunged records. We suggest extending the destruction of records to felony conviction records following automatic relief, as well as the destruction of records following court-granted relief. We're glad to see this committee is taking seriously the need to revise the penal code. Thank you for the opportunity to comment, and please see our organization's submitted written comments for additional detail.
Thank you.
Wayne Winston.
Hi, Wayne.
Hello, everyone. My name is Wayne. I'm also a clean slate attorney. I was informed about this meeting by my colleagues at LSPC, so I want to thank them and thank you guys for inviting the public. I am also really impressed with the recommendations. The one question I just had was, and I haven't prepared anything really tight in terms of my comment, but the question is about destroying records versus sealing and just a concern over the way that record clearance companies or background check companies will have access to sometimes records that have already been dismissed. So I'm concerned about if a record has been completely destroyed, and let's say that person needs to go back and make sure it was correctly, notated as dismissed because it's still showing up on a background check. I just wonder how we would make sure that that at least when something is sealed, the person has the option to unseal it to correct the dismissal, and then have it resealed. So what does destroy mean versus sealed, and how do we deal with issues of when background check companies continue to have traces of that record without having to like sue the background check company?
Yeah, I think that's an interesting issue that we should, consider as we look forward about that because the information will be sucked up in private databases forever. All right. Thank you all. Obviously, we continue to take public comment in writing. So if you have more detailed or other ways you want to comment on what we're doing, please contact committee staff through our website. Thanks everybody for joining this morning. And our next meeting, it will be Friday, May 15th, where we expect to discuss, as Tom mentioned, common sentence enhancements, aggravating factors, Rule 17B, Penal Code Section 17B reductions, and other related matters. Thank you all. Have a great weekend. Thanks especially to our staff, and I'll see you next time.